So I would like to welcome Senator Lynch Prata, who has done the service as she has her own committee meeting to explain the sub B as written. Before we had the sub B, there was the original bill, which was thoroughly vetted by the Judiciary Committee, so I thought it was appropriate that was already done, and that the committee and the hearing should hear from the Chair of Judiciary on the details of sub B. Thank you very much, and go ahead.
Thank you, Mr. Chair, and thank you to the committee for allowing me to speak on this today. As the committee heard, there was a bill that was put in by Representative Williams in the House. We did have a Senate version that was mirrored by Senator Goldin, so I do want to thank Senator Goldin for all of the work that she's done on this bill. There are three substantial changes that were made to Representative Williams' bill between the time we heard it and now. So what I do want to do for the committee is just review those changes with you. If you will go to page 2, line 29. This change surrounds the issue of post-viability, so-called. And as everybody who has entered this building, turned on their television or opened their web browser in the last 3 or 4 months, has seen, heard, or read that there was a great concern that this original bill was going to allow post-viability terminations up to day of birth. There seemed to be a concern that a woman could walk into her doctor's office at 8 or 9 months, suggest perhaps that she had anxiety or some other, minor illness, and ask for a termination. That is absolutely not the status quo. There is no doubt whatsoever that does not happen in the state of Rhode Island. What we did do, and with the help of Senator Archambault, who worked diligently with me on this legislation, as well as many of the other senators, particularly Senator Oyer, Senator Coyne, and Senator McKinney, were all instrumental in comparing the statutes that have been passed by other states, looking at Rhode Island's own laws, which have already been enacted, including those regulations in the Department of Health, which govern the licensure of the physicians who perform these terminations. So specifically, what the additions we made indicate is that a physician who performs a termination post-viability is required to put into the patient's medical record the medical basis, the basis for which the physician's medical judgment, the basis for the medical judgment that was used in the decision that the termination was necessary to preserve the life or health of the mother. In addition to that, we added in the direction to an already existing statute 23-3-17, which is the fetal death registry. And that statute indicates that any fetus after 20 weeks gestation, if there is any sort of fetal death, termination, or the like, that be reported to the Department of Health. And this indicates very clearly that any requirements under that statute for physicians also be placed into this statute. Again, that's not an addition to our current standard or our current status quo. It makes it very clear for those people who had concerns that there was this run on post-viability terminations that there is a standard, there is a place in which the doctor has to answer for any decision that is made. The other piece that I think it's important to point out is that any of these post-viability terminations are performed in hospitals by physicians. This is not something where you could walk into a doctor's office or a clinic and have this termination occur. The next addition in that statute, in that section, begins at line 33, where we make clear again that the Department of Health is authorized to deny or revoke any license to practice allopathic or osteopathic medicine or otherwise discipline a licensee upon a finding of the board that the person is guilty of unprofessional conduct pursuant to 5-37-5.1, paragraph 31. Paragraph 31, if you then turn to page 13 page 12 of the bill, line 27, is an addition to that Department of Health regulation that indicates that knowingly violating the provisions of 23-4.13-2D is a violation of that Department of Health regulation, therefore subjecting the doctor to any type of discipline or revocation of their license. The next change comes on page 4, beginning at line 6, referencing the felony assault statute. The additions made in here were to alleviate or attempt to clarify the concerns of those who felt as though the repeal of the so-called quick child statute could result in the assault on a pregnant person not resulting in a felony. We added to this section that an assault upon a pregnant woman by another resulting in the termination of the pregnancy would be a felony assault. It's important to note that the assaulter, the attacker, would know or have reason to know that the person that they attacked was pregnant. Again, if that attack or that assault results in the termination of the pregnancy, that person will be guilty of felony assault. That section also makes it clear that it is not applied to any person in performance of an abortion pursuant to the Reproductive Privacy Act, and that statute is cited. And it further indicates that any person for any medical treatment of the pregnant person or the fetus, so that if a person is seeking medical treatment and some sort of accident occurs, that would not necessarily be felony assault. Certainly, there would be other remedies under the law, but that was not the idea of that assault statute. The last change, and it wasn't an addition, it was actually a subtraction. Representative Williams had put in her bill with respect to the parental consent piece. So as you all know, in our law, in order for a minor to seek a termination of a pregnancy, they must have parental consent to do so. This statute originally sought to expand the ability to consent to that procedure to grandparents or siblings over the age of 25 who did not have legal guardianship or other legal status. I certainly understand Representative Williams' intent in adding that language into this statute. However, the concern that I had, as well as many of the other senators in going through this bill, was that the goal of this bill and the goal of enacting the Reproductive Privacy Act all along was to codify the current status quo, was not to expand nor to restrict any of the rights that currently exist today. This, to me, was a clear expansion of the rights that exist today. There is nowhere else within our statutory scheme that someone other than a parent or a legal guardian can consent to a medical procedure of a minor. Again, I've discussed this with Representative Williams, and this is something we can attempt to work on in another aspect, as she has, very real concerns within her community that there are a lot of grandparents raising children or older siblings raising children. To me, it raised too many issues, but the biggest one was that concern of the expansion of any rights that we currently have. So again, I just want to say that I understand that this is a very personal issue to a lot of people. I know this is an extremely important issue, not only to everyone in the Senate, but also in the state of Rhode Island. I assure you that we worked as hard as we possibly could to codify our current status quo, and I believe what you see before you today in House Bill 5125 Substitute B is that codification.